For our story today, we're covering a story out of North Carolina where a man's wife cheated on him and left him. But the husband was able to get some sort of measure of satisfaction because the husband sued the lover for stealing his wife and won an award of $750,000 from the lover of his wife who stole his wife away. This is called alienation of affection and is a tort recognized in North Carolina and a few other states. So we're going to read a little bit of this article, and then we're going to read something that gives a very good summary of this law so that we can understand some of its rationale. So let's get started. From Greenville, North Carolina, a Pitt County man has won $750,000 judgment against another man for alienation of affection for stealing his wife away. She originally told me she wanted a divorce because I worked too much. I wasn't around there and I worked too much. I started to talk about it as part of my mistake in the situation, but it was like a punch in the gut because I thought I had this trust for 12 years of love. Although adultery is sometimes romanticized, in reality, life cheating with someone married and causing their divorce is illegal in North Carolina and 6 other states. Hawaii, Mississippi, New Mexico, South Dakota, Utah, and North Carolina still hold on to alienation of affection. So I'm not sure how Hawaii got into this list, being a more left-leaning state, but it is on the list of places where alienation of affection is a recognized tort. So I thought what we do is we read an article that I found that very nicely summarized the law. So this is called an in-depth discussion of alienation, affection, and criminal conversation. So this is written by a lawyer, and I thought it presented a good summary of the law. So we'll read this so we can understand some of the law that goes into this issue. What elements do you have to show to make a claim of alienation of affection? The essential claims of alienation of affection are that the husband and wife have a marriage of genuine love and affection. The love and affection existed between the husband and wife was alienated and destroyed. The lover wrongful and malicious conduct was the contributing cause, and the alienation has caused damage. First, it's very important to consider the elements of this claim are tricky because of its nature. What is genuine love? How can a jury determine whether love and affection existed? Does a third party have to have sex with the spouse in order to cause him or her and alienate the affection? How can you determine what is wrongful and malicious conduct, or the conduct was a controlling cause? What kind of damages are we talking about, and how can you put a dollar amount on the relationship lost? It's hard to pinpoint the definition of genuine love and affection. Alternatively, let's consider some factors that may tend to show when genuine love and affection did not exist. This element is incredibly important because it offers the strongest defense. For example, if the married couple had been in counseling or discussed separation for many months or years prior, it's likely one could argue there no longer existed genuine love or affection. While it's possible this is the strongest argument, there's some North Carolina case law that suggests otherwise. One case involved a married couple who had separated prior to the involvement. The separation was not important. The fact that the married couple had resumed their relationship was evidence they somehow managed to maintain the necessary genuine love and affection for the purposes of the claim. Other case law suggests that even if plaintiff had an affair during the marriage, then the genuine love and affection is still not negated for the purposes of providing that paramour's wrongful conduct led to the alienation of the spouse's affection. That's pretty interesting. So if you have an affair, but you get back together, and then the other spouse has an affair and they leave you, you can still sue. So that's an interesting turn of phrase in North Carolina law. As you can see, these cases are very fact-specific. Thus, whether a marriage had genuine love and affection is ultimately a question for a jury, how we decide many of these issues. The element that love and affection between husband and wife is destroyed is typically clear if the married couple is separated or divorced immediately subsequent to the relationship with the cheating spouse. The lover's wrongful and malicious conduct was the controlling or effective cause. This element can be broken down into 2 parts. First, what is malicious or wrongful conduct? According to Black's Law Dictionary, every sovereign citizen's favorite dictionary, but still a valuable resource for those of us who know what we're doing, malice by definition is the intent without justification or excuse to commit a wrongful act. In cases of alienation of affection, malice is presumed if the act of seduction, or adultery is shown. However, other actions performed by the paramour may rise to the level of malicious and wrongful conduct. For instance, conduct such as excessive telephone calls to and from the plaintiff's spouse or scheduling secret rendezvous may be enough for a jury to consider the conduct malicious and wrongful if a jury determines the paramour knew of the potential harm. Second, to establish this element, one must show that wrongful acts of the defendant are the controlling or effective cause of the alienation, if there are other causes which may have contributed. Must the paramour have instigated the resulting alienation? Not necessarily. Affirmative conduct from the paramour will be sufficient. For example, in one North Carolina case, the paramour involved with plaintiff's spouse said to the plaintiff, "I'm sorry to have done this to you." What this was coupled with, evidence of a hotel reservation, is enough for a jury to find the paramour's conduct caused the plaintiff's spouse to alienate her affections from him. Moreover, there's no need to show the paramour was motivated by ill will towards the plaintiff. Finally, there's no need to show the spouse and paramour even had sexual intercourse in order to prove the alienation of affection. Nice. Damages are typically defined as monetary compensation for a loss. There are two types of damages to be considered: compensated damages and punitive damages. Compensated damages are damages that compensate the plaintiff for the harm caused by the conduct. Generally, those damages will include expenses incurred for therapy costs, prescription medication costs, loss of services in the home, for such as day-to-day chores, loss of spousal support, loss of consortium, which means loss of sexual relationships, so you can sue for loss of sex, outstanding, emotional distress, injury to the plaintiff's reputation, cost of litigation for the divorce, and other causes related. Punitive damages are damages intended to punish the defendant. For the question of punitive damages to be submitted to a jury in an alienation of affection case, there must be evidence of circumstances of aggravation beyond the proof of malice necessary to recover for the compensation damages. These specific circumstances of aggravation include willful, wanton, aggravated, or malicious conduct, so the plaintiff must show evidence of malice. If the paramour and the spouse had sexual relationship, it's likely malice will be implied. Do you cite a hooker's rates in determining monetary damages for loss of sex? That is a hilarious thought. I don't know. It's a pretty interesting idea, though. You go figure out the market rate for prostitution is and use that as a basis for damages. That's something evil, Tribble. You have a mind that's valuable in law. You're too good for this world. Become a lawyer. Second, a plaintiff must show defendant aggravated the conduct. Some say the defendant poured salt into the open wound. What are some specific circumstances of aggravation? Well, in one case, sufficient evidence of aggravation to justify punitive damages award existed where a plaintiff presented evidence that plaintiff's spouse and defendant had had sex at least 2 times. The defendant accompanied plaintiff's spouse when returning the children to custody of plaintiff. The defendant appeared unannounced at the front door of the marital home to ask plaintiff if they could be friends. And defendant arrived at the driveway of the marital home while plaintiff was visiting his children. Other circumstances that might suggest the circumstances have been aggravated by defendant's conduct may include defendant calling and meeting plaintiff's spouse hundreds of times while having knowledge of the marriage. I'm going to move to North Carolina and become a specialist in this field of law. I feel a calling, guys. You know, my parents' home is very, very near the North Carolina border. So I'm just saying I could move down there, become a North Carolina lawyer, and I could take on alienation of affection cases in Charlotte, man. It'd be awesome. Maybe I should change careers. I feel a calling. I could hire some PIs. They can go on stakeouts. It'd be great. Under North Carolina law, punitive damages are never awarded merely because of personal injury afflicted, nor are they measures by extent of injury. Rather, they are awarded because of outrageousness of the defendant's conduct. However, with outrageous conduct established, a jury may still not find defendant should be punished. Finally, in order to recover punitive damages, the jury must first award compensation damages if those damages are nominal. Then, depending on evidence presented, a jury can determine whether evidence is sufficient to show punitive damages will also be awarded. $750 make for one hell of a commission if you go on contingency. Yeah, if you go with a normal 30 to 40%, you're looking at a payday of $250,000 to $300,000 plus expenses. So, $250,000 to $300 plus expenses. So many people get screwed out of this relationship. Yeah, I can hire Evil Tribble to investigate market rates. That's right. Yeah, I'm gonna hire a personal investigator, and your job as personal investigator. I know it's a tough job, but here's what I want you to do. I want you to go forth into the prostitution industry, and I want you to find out from firsthand experiences what prostitutions are charging. And I can write it off as a business expense. Wow. This is the potential here is mind-numbing, guys. I have to say, I'm kind of thinking about it a little bit. I know I'm joking, but kind of thinking about it a little bit. Patent law is a little dry, man. I never wanted to go into family law, but this is a whole new world, man. Scorned lovers are us, the Scorned Lovers Law Firm. We'll get back. We'll get back at your ex, no matter the cost. Man, too much fun. And that's great because you know what's going to have to happen, right? You know what's going to have to happen when I'm figuring out the charges for alienation affection? You know what has to happen, right? I have to put an expert witness on the stand. I have to put an expert witness on the stand, which means I have to put one of these ladies on the stand. And of course, being a good lawyer, I have to sufficiently prep my witness so they know how to answer questions on the stand. So I can also charge my client for the prep time as an expense. Yeah. I'm going to give lawyers a bad name, guys. I'm just saying. This is happening now. Oh man. So that is our story for the alienation of affection case from North Carolina and other states. So, lesson learned here, I guess, if you're going to try to, if married women are your type, you may want to stay out of these states when trying to seduce them because you're just asking for damages to be held against you. So, if your next convention is in Charlotte, North Carolina, and your type are married women, you just might want to stay away because it looks like it might be more trouble than it's worth. Just pro tips to the wise. My expert witness would be the pimp. They match the wife's description with a suitable partner. I mean, there's many ways to address this issue, guys. I mean, I just like the fact that I can bill my client for a third to 40% for my contingency fee, and then expenses and legitimate expenses might include such things as surveying the prostitution community to get an idea of rates of services for loss of consortium claims and getting them on the stand to testify. Yeah. Yeah. And prepping their witnesses. Much prep time needed. Drive down to Rock Hill, South Carolina, do your dirty deeds, I guess.